welcome everybody, because we will be posting this recorded session online and distributing it through the Asian Australian Lawyers and other professional legal association networks this evening. We have David Ray, who is a former judge of the Special Tribunal of Lebanon, joining us this evening for a special session about the international law context when it comes to judicial bias and applications for judicial disqualification. Wai Kaey Soon, who's immediate past president of the Asian Australian Lawyers New South Wales branch, will be asking David some questions to get David to introduce himself, and so we can find out a little bit about David's background and experience as a legal practitioner. So I'll hand over to you, Wai Kaey.
All right, thank you, Lee May. Yes, as previously discussed, this is a pre-recorded session in relation to a seminar which is going to be held in relation to judicial impartiality in the age of COVID-19. My interlocutor for this introduction is Judge David Ray of the Special Tribunal for Lebanon. I might just jump straight into the questions. Judge, could you please tell us about your background as a lawyer and your journey which led to the appointment on the Special Tribunal for Lebanon?
Well, good evening. It was thank you for having me. It was a long, interesting journey. I graduated in 1986, and my first job was working as a junior solicitor on the Chamberlain Royal Commission into the inquiry into the convictions of Lindy and Michael Chamberlain. I was working for the Chamberlains and with some of Australia's best lawyers, and I was the junior solicitor. Then I went into private practice briefly as a solicitor. Then I went to the New South Wales Director of Public Prosecutions. Then I spent a couple of years in the Attorney General's Department in Sydney in the Criminal Law Review Division, doing criminal law policy work. And then I went back to the DPP for a number of years, where I worked firstly as a professional assistant to the Deputy Director of Public Prosecutions, then doing trial work. Takes us up to 97. And then I went to the bar. I was there for 5 years. And then I went to The Hague and worked for the International Criminal Tribunal for the former Yugoslavia. That's the ICTY, where I was a trial attorney, that's a prosecutor, and then a senior trial attorney, where I did a number of trials of war crimes, crimes against humanity, and an appeal. The last case I did there was prosecuting the former Prime Minister of Kosovo, Ramush Haradinaj, for allegedly committing war crimes and crimes against humanity. Then I went to Bosnia and Herzegovina as a judge of the War Crimes Division, an international judge in Sarajevo, where I was for 2 years. Did a number of trials, including one of the Srebrenica genocide trials. Then I was appointed as a judge of the Special Tribunal for Lebanon in The Hague. I also did a bit of legal consultancy along the way. For example, I worked in South Sudan for a while, working for the United Nations Development Programme, the UNDP, during the secession referendum in 2010 to 11. Did some consulting for the Organisation for Economic Cooperation and Development in Europe, that's the OECD in Macedonia. And I spent almost 10 years at the Special Tribunal for Lebanon, last 7 as the presiding judge of the trial chamber, which was dealing with the assassination of the former Prime Minister of Lebanon, Rafik Hariri, in a massive car bomb in Beirut in 2005. We delivered judgment in August and the sentence in December. That, in a nutshell, is my career so far.
Thank you. The next question is, for Australian lawyers and Australian law students who are interested in practicing in international law, what can you tell them about the international legal job market, such as it is?
Well, it varies. At its height, the ICTY, for example, had maybe, I think it was up to about 1,200 employees in The Hague. It's now devolved into a residual successor mechanism with the Rwanda Tribunal. It's much smaller, it's got a few hundred. So the number of jobs in international criminal law for lawyers has actually decreased. There aren't that many, there are more jobs in international criminal law than there are in the other divisions of international law, public international law, for example, and the various other tribunals, such as the Permanent Court of Arbitration and the International Court of Justice. There aren't very many jobs there. It's a very tight market. So my advice, if you wish to get into international criminal law, and I give this to interns all the time, is to try and get yourself at least 5 years of domestic experience so that you're making yourself useful to the institution that you are going to work in. So I'd recommend several things. One is to, if possible, do an internship in one of the courts and tribunals. It doesn't matter which one. So you get yourself some international experience. Of course, do a master's degree, quite important, with some international law aspects. It doesn't matter that much which one, but if you want to do international criminal law, it doesn't hurt to have done a course in that. And the third one is to make yourself competitive, especially if you're coming from a country which can be overrepresented, and geographical representation may be quite important in to have a balance in various courts and tribunals, is to have a second useful language. Now, the most useful language, second language, English is the most useful, obviously. It's the lingua franca, is French. And yeah, I can assure you it's getting to a level of proficiency where you can work in French is not easy. Now, Spanish is another one, and Arabic. They're the other ones. Spanish, you've got the whole of South America, various commissions and so on, which there might be work there, and also French, of course, in Geneva. There's various international law institutions in Geneva, and Switzerland, which of course is a French-speaking country, city in Switzerland. But I think the only UN institution which has French as official language is the International Postal Organization, I think, from memory. So yes, master's degree, work for 5 years, get yourself do an internship if possible, and learn French. How's that in a nutshell?
Very useful. That last advice to learn a useful language hit home quite a bit, because my language was Latin, and that has been absolutely unuseful in every possible sense.
Well, it's the base for Spanish and French,
yes,
for example, and a lot of English.
Yeah. So, in what way have you been involved in working with lawyers who may not necessarily be qualified in a common law country, and with any experience in international law?
Well, that's most of them.
Yes.
If you divide the world into the common law and civil law systems, they're not the only major legal systems in the world anyway. It's about a 65-35% division in favour of civil law. So statistically, yes, you're much more likely to be working with people from a civil law background than a common law background. Now, over the years, I spent the first 15 years working exclusively in common law. Then I spent 6.5 years at the ICTY, which was a hybrid system, mixed common law and civil law. Then 2 years in Bosnia, which is a civil law system based on the Germanic tradition. And then the last 10 at the Special Tribunal for Lebanon, which again is a hybrid system, which is base most of its rules on those of the International Criminal Court and the ICTY. There's obviously people, there are very different legal procedures between the common law and civil law systems. Although, having said that, there is no one common law system and there is no one civil law system. In Australia, there are 9 common laws, depending upon the state. And in the United States, for example, there are 50 states, a Supreme Court, and 9 circuit courts of appeal, federal courts of appeal. So effectively, there are 60 common laws there. And you go to just going to Europe, for example, in criminal law proceedings, some have investigating judges, some have abolished investigating judges, some have partie civiles, which are victims who can participate in proceedings, some don't have it, some have distinct prosecution cases, some don't. So the hybrid system which I've been working is a mixture of the two, but it's adversarial. So virtually, I mean, every case I've done, it's been a mixture of civil lawyers and common lawyers, and some people who've only, unfortunately, I say this, some people have only, unfortunately, worked in hybrid systems, so they don't have any experience of their own systems. Now, look, just as a brief example, in the last case I did as a prosecutor at the ICTY, the case of Haradina and 2 others, I think I was supervising a team of about 20. And from a memory, I think there are about 14 different nationalities in that team. So it makes it quite interesting. Of course, it's more interesting if you're on a bench. If you're the senior prosecutor on a case, you're making the decisions, you're signing the filings, and you're responsible for the arguments in court and the conduct of the case. So ultimately, you're the decision maker. If you're working on a bench of 3 or 5, it's joint decision making. And if you're doing it with people from very different linguistic, cultural, and legal backgrounds, quite frankly, it's amazing that you get to any decisions, let alone good ones. So it's incredibly challenging, but it can also be very, very rewarding and frustrating at the same time. You learn an awful lot, and one of the things you do learn is to suppress your own nationalistic, legal and cultural ego. Well, you try to be, you have to be very humble in these circumstances, because especially if you're working in a field which isn't relating to your own country. For example, at the ICTY, coming as an Australian, well, what do I know about the war in the former Yugoslavia? What do I know? What do I know as an Australian judge, being the presiding judge on the trial of 5 accused charged in absentia with the assassination of Rafi Hariri in Lebanon? What do I know about the Lebanese political and cultural background? A lot of Lebanese people in Australia, but that's hardly certainly when I was a lawyer, I acted for Lebanese, I had Lebanese friends and acted for Lebanese people in the Lebanese community, but it doesn't place me in it and doesn't give me a cultural insight into Lebanon itself.
Yeah, thank you very much. I think that's it for my question, so I might move over to Li Mei, who's going to do the second part of this.
Thank you very much for that. I almost feel like we could just fill the whole session with a discussion about your experience with working in international courts
Yes,
and the international law. But I'm sure it will be very useful commentary and knowledge for some of our members who are interested in looking at working in the international context. This evening's session, though, is focused on the topic of judicial impartiality and in particular applications for judicial disqualification. David, can you tell us a little bit about your experience in the international context when it comes to the test for judicial disqualification? Is there an international test for judicial disqualification?
This is well, yes and no. I mean, ultimately it comes down to impartiality and independence. I mean, you go back to the international human rights instruments, Article 14 of the International Covenant of Civil and Political Rights, and others such as Article 6 of the European Convention on Human Rights. Now, the Human Rights Committee has decided this. It's an absolute right. It's not derogable. The European Court has had a journey over the years. There was a case, I think, in 1970 where a Belgian case where a prosecutor, the case was that a prosecutor had participated in deliberations of a court of cassation, which is an appeal court, and of course it would be unheard of in a common law country that a party could participate in judicial deliberations. But because they were seen to be independent of the judiciary, the European Court in 1970 decided that was okay. Now it's since changed. There's been a progression, and now, of course, it isn't okay. But the test basically comes down to the same as in Australia, which is apprehended bias and actual bias, although in different courts it's been called subjective bias and objective bias. Most of the case law comes from the criminal courts, the Yugoslav Tribunal, the Rwanda one. There were numerous applications for disqualification. The International Criminal Court, the ICC. Then, of course, you've got all the civil courts and tribunals, the Permanent Court of Arbitration, the International Court of Justice, the World Trade Organization's panels and appellate panels, UNCLOS, that's the UN Convention on the Law of the Seas Tribunal. So it's not just a matter of each of them has their own procedures. Some of them the judge can ask to be excused, and the president agree. Others, for example, at the Special Tribunal for Lebanon, if there's an application for disqualification, it's made to the president, who appoints a panel from a roster. There's a roster of 3 judges on a monthly basis, which would be 1 Lebanese judge and 2 international judges. And then they decided after hearing from the judge. And the 3 judges make a decision which is non-appellable. So if they decide you're biased, boom, that's it. There's no appeal from it. That's one model. Another model is at the International Criminal Court, where where a judge can ask to be excused and the president can allow that. There's an application for disqualification. It goes to a plenary of the judges, and that's 18 judges. Now, of course, if you think about that immediately presents, from which there's no appeal, it presents immediate problems, because if you're applying to disqualify an entire trial chamber or a pre-trial chamber of 3 judges, perhaps with an alternate judge attached, that'd be 4, and you've got 5 appellate judges who are also sitting in the plenary, and it has to be an absolute majority under Article 40 of the Rome Statute who decide whether the judge is biased, should be disqualified. So straight away you've got 9 judges who can't participate in the proceedings. So you've lost your absolute majority. There was a recent report of an independent review of the ICC which recommended setting up an independent council of judges outside. So it's basically all over the place. Each court and tribunal has its own rules and its own procedures. The ICJ has it set out in its statute that a judge cannot have been a national judge involved in the case, or a party, or a council, or an agent, that is, such as an ambassador, who's the agent in the case. Each one has its own set of procedures. It's very different to Australia, where the judge makes their own decision. At the Special Tribunal for Lebanon, for example, which is slightly different to others, once the application is made, the judge can no longer participate in the proceedings. So if an application is made to disqualify an entire trial chamber, boom, the proceedings just grind to a halt until a panel of 3 judges can determine the matter, after, of course, hearing from the judge and hearing from the parties. that is the defence and the prosecution, or vice versa. That can considerably delay things.
You mentioned that there's no right of appeal from these applications. Are there any other, and you've touched on the fact that it's procedurally quite different to what happens here in Australia, where in the majority of jurisdictions, it's the judge, which is being sought, a party is seeking to recluse, who decides the application themselves. Comparing those quite distinct different procedures, do you have any comments about any limitations in a system which might involve another separate panel deciding the application, or the president of the court, an application going to the president of the court?
Well, not with the application going to the president, because the president's role should be administrative. That is, they are mandated to appoint a panel. So it might as well go to the registrar. It doesn't matter where it goes if that person is just the conduit to getting it to an independent panel. The problems I see, the conceptual problems, are the lack of an international judicial justice system as such, and the lack of a right of appeal. In Australia, if the judge refuses to disqualify themselves, it can be appealed, and well, there could be several levels of appeal depending upon what happens. To my mind, that's a far better model. I'm not just saying that because of my own, I'd like to think, my own biases coming from the common law system. I genuinely think it's a better system. The plenary of judges is a very, very bad model. I experienced this myself as a judge in Bosnia, where an application was made against me to disqualify myself in a case, and I had to go to the plenary of maybe 40 judges, I can't remember, and tell them. I think the ground was I think I'd asked too many questions in a genocide trial, and the defence objected, and the plenary unanimously decided that wasn't bias. But I'm sitting in the plenary after having made my submission, my response to it, and then the other judges vote on whether I'm biased or not. In a plenary of 40 judges, it's not such a problem, but in a plenary of 18 judges at the ICC, the example I gave before, it is a problem. The ICJ, for example, the International Court of Justice, there are only 15 judges, and if the judge refuses to disqualify themselves, it will go to plenary of judges to decide it. Or it's called the court. Although there's no precedent. I understand there've only been 3 applications made in the life of the ICJ since 1945. The other thing which is fundamental is that there is no system of justice, no unified international system of justice. All of these courts and tribunals operate independently and according to their own statutes. Some are UN bodies, such as the successor mechanism to the Rwanda and Yugoslav tribunals, which is called the International Residual Mechanism for Criminal Tribunals, or the IRMUCT. They're UN. That's a UN body. Others are panels attached to the treaty, such as the Law of the Sea or the WTO. The ICJ is the United Nations judicial arm. Now, the problem is these are all decided internally by judges who are essentially colleagues, some of them in quite small courts. Special Tribunal for Lebanon, for example, has 11 judges. There have been a number of applications for disqualification which go to a random panel of 3 judges, some of whom could be theoretically sitting with the judge on the panel, like an appeals panel of 5 judges. And that's a very unsatisfactory way of dealing with it. So a much better model would be to establish an independent panel of judges from other courts, a standing panel which could be convened to deal with disqualification applications. Now, within that, you could also have an appellate level. It goes from 3 judges to 5 judges. All you need is 8 judges to do it. and you take it from all the various members from the various courts and tribunals to do it. That would provide, but that of course would require cooperation between the courts and tribunals and United Nations and various other organisations to do so. But it could work. Look, I'll give you some examples from which people could judge. I mean, just in the criminal context, at the ICTY there were dozens of disqualification applications against the judges. Only 2 were ever successful. But there were all sorts of applications, such as one judge was appointed as the vice president of Costa Rica when she was on a trial. Another one had the ICTR. Another one, a judge from Senegal, who was the presiding judge in the case called Caramera, had offered, had been sharing a house with a trial counsel for the prosecution in Arusha in Tanzania, but had done so before she was appointed to that case. It was another lawyer from Senegal, and before the case had started. But the judge forgot to disclose it to the parties. When the defence found out, they went ballistic and made a number of applications. But those were decided by the Rwanda Tribunal, by a bureau, which was the president, vice president, and presiding judge of the chambers. They decided that there was no grounds to disqualify the judge until the judge eventually withdrew and another judge was put in her place. So they're an example of an unsuccessful application. At the ICTY, the only 2 successful applications were one Judge Hahoff, and it was the end of a long trial of a Bosnian Serb nationalist for crimes against humanity. During the deliberation process, he one night sent an email to over 50 of his closest friends, criticising some aspects of the way judgments were made in the tribunal, including raising some aspersions on the integrity of the president, Judge Miron, and one of his close friends, or someone else, leaked it to the Danish, he was a Danish judge and professor, leaked it to the Danish press, and the defence sought his disqualification. Now, it went to a 3-judge panel, and the decision was 2-1 that he was to be disqualified. There was one judge, a Chinese judge, Judge Liu, who said, well, it was deplorable behaviour, but didn't quite rise to the level of partiality. So the unfortunate result of that was Judge Hahoff was out. Judge Hahoff was what's called an ad litem judge. That's a judge assigned only to a particular case. He wasn't a permanent judge. So that was the end of Judge Hahoff's international career. And the case, which had no alternate judge who could have stepped in, was left with 2 judges, a French judge and a Italian judge. 2 judges in the deliberations when you must have 3 judges. So they appointed a 3rd judge at the deliberation stage, who had then had to watch the tapes of the entire proceedings. And then there was a 2-1 acquittal of Shechel, with the new judge in the majority with the French judge. So that was one. And the only other one was an application in the successor mechanism of what's called the MICT, to disqualify 3 judges from the appeal from General Mladic's appeal. Mladic was the Bosnian Serb general, the head of the Bosnian Serb army, who was charged with genocide, crimes against humanity, and war crimes. The grounds of the application were that 3 of the judges, Judge Aegis, Meron, and Liu, had made decisions in trials or appeals finding that Mladic was part of a joint criminal enterprise to commit basically ethnic cleansing in Bosnia. They'd already predetermined his role in the what the joint criminal enterprise alleged. Now, previously, the case law had been, well, that doesn't matter because it's a separate case. But this time, because of the way the new mechanism was working, it fell to a single judge, a French judge, Antonetti, to make the decision. And he decided his 3 fellow judges of the appeals chamber were biased and disqualified them. That was non-appellable too. So one judge decided 3 were three were biased on that basis. Now, I think the decision was correct because of their previous decisions. So in the entire history of the ICTY, there were only two successful, or the MIC, two successful applications. Now, the ICC, they had a number there too. One of the most recent, some of them have been about judges making prior statements or their involvement in organisations before. One of the most recent was in the Ntaganda case, where, again, in the deliberation stage, and again, three judges, but without a alternate judge being able to step in, a Japanese judge who'd been a diplomat, not a lawyer or a judge before, Judge Ozaki, in the deliberation stage, after the close of the case, accepted an appointment as the Japanese ambassador to Estonia. And she'd sought the plenary's approval to do so, but first without disclosing it to the parties. The plenary had decided by majority that she could, and then she accepted the appointment, went to Estonia but didn't present her credentials. Meanwhile, the defence presented another application for her disqualification based upon the fact that she was not independent. Now, the appeals chamber judges disqualified themselves, all five of them. The judge, Ozaki, couldn't, well, she was no longer a judge, a permanent judge at that point. And the plenary decided by 10, which is an absolute majority, that there was no question of there wasn't a question of independence. So the ICC plenary of judges decided one of their own could continue to be the ambassador, the Japanese ambassador, while serving as a judge in a case. Now, ambassador, of course, is not just a representative, but the mouthpiece of a country. So you have a judge who is part of the executive of a country, while at the same time being a judge who is not supposed to be taking instructions from a government. Now, my response to that was, well, pose the question, what if she'd been appointed the Japanese special or permanent representative to the United Nations, or the ambassador to the Hague in the Netherlands, where the seat of the court is, or to one of the countries involved, such as Uganda or the Democratic Republic of the Congo, might have reached a different result. So it was then dealt with on appeal. The defence raised the issue on appeal. The appeals chamber said, well, you can't appeal against the plenary's decision, but you could appeal on a fair trial basis, that her participation in the deliberations would make her biased to the point that there was an unfair trial. So there are different ways of dealing with it, but ultimately it was decided that there was no prejudice, no actual prejudice to the defence. So yeah, it's hugely interesting. A lot of these, you wouldn't encounter these things in Australia.
No, I don't think so. Thank you very much for that, those remarks and that overview, which is very helpful and very valuable. I might just, for the rest of this, hand over to Ronny, who I think has got some further questions for you.
Thank you, Li Mei. Hi, Judge. My name is Ronny Chen. I'm at Frederick Jordan Chambers as well. You've mentioned that in the international setting is really a hybrid system. So I'm sure in your work you've had to deal with challenges posed by potential bias from the bench. Now, I really want to explore with you the use of technology in the age of COVID-19. Now, I'm sure there has been many remote hearings in your work. Do you think that the issue about bias from the bench can be assisted by technology somehow, or do you think that technology is going to amplify the issue of judicial bias?
It's very difficult to say. I can't say one way or another. My experience has been of many remote hearings, especially with witnesses via video conference link, and they're certainly more efficient in terms of time and cost saving, but they also present some fairly unique challenges in terms of assessment and communication with witnesses, which of course can amplify unconscious bias, but on the other hand, it can make you perhaps more conscious of it and do what you should do in these circumstances, which is to slow down, don't make snap decisions, and take time to reflect and consider things. So I think it's too early in terms of remote hearings to make a judgment. Yeah.
Right. And
if you have any thoughts on it, please share them.
I don't think I'm experienced enough to provide any useful comments at this stage. But just so, what tips do you have for a lawyer who, for example, in the middle of a hearing, suspects that there may have been some unconscious bias from the bench against the litigant because the litigant is from a diverse cultural background?
Well, it depends on the context and what's been said. It could be gestures, it could be the way a judge comports themselves, the expression on their face. It could be direct questions. It could be decisions, rulings. My advice is, of course, to be polite but firm, as you have to be. But depending upon what's being said or what's occurring, is to ask the judge to reconsider or to reflect upon what's going on. Sometimes it's advisable, in many cases it would be, to speak to your opponent before. A united front is a better front in these cases. And you, of course, have to preserve the record by politely but firmly putting onto the record what has actually been said. Now, if it's not, if it's audio, of course you can, which cases are, you will of course be able to detect differences in tones, and transcript will reveal what was said. If it's not videoed, well, that presents another challenge. But I suggest that you act as soon as you can, so to prevent any prejudice to your client, or basically the system of justice. It's very, very important to preserve the integrity of justice. So it's always a delicate balance, because you don't want to provoke. But on the other hand, I think judges these days are much more sensitive to the issues and don't want to be seen to be part of what used to be an old boys club, and where it was just normal to carry on like that. But of course, with the increased diversity of the bench, ethnic and gender, I think you're going to see a lot of changes. It's far healthier. When I came to law, I don't think there are any Supreme Court judges in New South Wales who are women. Certainly no Asians. An Asian woman, God forbid, in 1986.
Well, I mean,
change the world. Change for the better, I can assure you.
That's right. Now, Lima, in the interest of time, I might just pause here. We've got Maria joining us. Maria, she is the current New South Wales president of the Asian Australian Lawyers Association.
Thank you very much for tonight's seminar, particularly to our guest, Judge Ray, and to our chair of the Data and Policy Subcommittee for New South Wales, Lee May, for arranging this, and our long-term members, Ronny, Chen, and Wai Kaey Soon, who was also our former president. We thank you for everyone who participated tonight behind the scenes, and for all our viewers to come. Thank you very much.
Thanks, Maria.
you.